Friends, we are today going to discuss a case law. And the case law is on a very burning topic, that is retrenchment. In our endeavor to bring you out case laws which are very latest in time, and I am going to simplify them. Today we are going to talk on the retrenchment. And there's a very latest case which we have, that is Solitaire Machine Tools versus Mr. Harish M Vaghela. This is a judgment, one of its latest kinds, is decided just in 2020 by Honorable Justice Sonia Gokani of the Gujarat High Court. Now what is this? The facts of the case are very simple, that there was a company. They had obtained a license from another company for having to sell some centerless grinders in the year 1987, and so on and so forth. The things were going on. Then something happened wrong with the market, which usually it does. There are so many vagaries in the market, the ups and downs, crests and troughs, sales get plummeted, and all of those things. And ultimately, there was no option with the company but to retrench some workmen. Now, this judgment itself is on retrenchment and is one of the latest of its kinds. Basically, before we begin, let us understand as to what is retrenchment. Retrenchment is the termination by the employer of the service of the workman for any reason whatsoever other than by way of a punishment inflicted by way of a disciplinary action. Now, there are two parts of the definition. One is an inclusive part, which I told you, and one is an exclusive part, that is, it does not include. It does not include voluntary retirement. If somebody just retires voluntarily and then say maybe by a VRS or something, that is not retrenchment. Retrenchment of a work because of a work person or a workman attaining the age of 60 under the model standing orders, if at all they are applicable to the company, the age of superannuation is 60. And with the efflux of time, he joins the company, becomes 60, goes home. This is not retrenchment. Third is non-renewal of contracts. So a contract which is not renewed, that also could not be retrenchment. And the fourth is continued ill health. That a person has taken up ill health and for years together he is lying on the bed and nothing worthwhile could come of it. Very unfortunate to happen with him, and he is passing sorry days, but yet that would be an exception to the retrenchment as far as the definition is concerned. Now friends, our discussion would be incomplete if I do not make a mention of some of the landmark cases which are mentioned in this judgment itself. The Honorable Judge has mentioned a case, Parry & Company Limited. Parry & Company Limited really delineates the total case law as far as retrenchment, of the theory of retrenchment. Parry & Company says that it is well within the managerial discretion to arrange and rearrange the business. See, I am the employer. I know the business. I want to arrange it in a specific fashion. So I will arrange it, rearrange it. Now, if this results in some sort of a surplusage, then a retrenchment would be inevitable. Now you see, there are some conditions to it. So long as this is done bona fide, well, then there is no problem. And if at all such a scheme of reorganization results in surplusage, that this becomes surplus labor, there is no work for me. And moreover, we cannot forget about one more thing, that manpower planning is a management subject. It's a management function, as promotion is a management function, manpower planning is a management function, transfer is a management function, so is arrangement and rearrangement of any business. And if I rearrange my business and which results in some sort of a surplusage, then the employer will not be held responsible. But the thing, as I told you, is it should be bona fide and it should not smack of victimization or of unfair labor practice. Now, when you retrench people, you have to give them a compensation. The law is laid down in section 25F, that is, conditions precedent to retrenchment. Conditions to precedent to retrenchment is granting him or giving him 15 days of average pay per completed year of service. Now, why is this important? This is just to soften the rigors, to mitigate the rigors, because he will be jobless, he will be out of the job. So the legislature in its wisdom intended that something has to be given to that worker, and section 25F says that 15 days of average pay per completed year of service has to be given. Now it is for the employer to decide whether the business is profitable, economic, it is doing well, it is as per his business notions, as per what he expects the returns, dividends, this, that, everything. But if at all the court finds that this is just a garb, this is just a facade, this is just an outward show, and under the pretense of a retrenchment, the employer has indulged into unfair labor practice, or he is really victimizing some workman, then he will be taken to task by the court if at all his action is challenged in some of the forums or before the labor court or the industrial court, wherever, all over India, depending on whatever is the jurisdiction. Now you see, surplusage, what is the basis? The basis is surplusage. Surplusage is the very basis of retrenchment, is what the Honorable Judge says in this judgment. Now friends, you see, the employer may want to cut down expenditure. He may want to just reduce the workforce, and he can do so. Question is that he may want to install some labor saving machinery, some labor saving some devices, and he will say you 1, 2, 3, you are becoming surplus, so this is your retrenchment compensation, and I bid you goodbye. Now on the face of it, somebody is losing his job. It appears a bit very emotional, sentimental, but then here there are a number of judgments wherein the employer is here not for charity, he is for business. So if he is into business, he is the sole judge to decide, howsoever inevitable it may be, howsoever it might shake the workman, if at all it is not within his reach, he will say, this is what the law compels me to offer you, and this is 25F, and this is your retrenchment compensation. Not that the workman has committed some sin, but the very definition of retrenchment says that retrenchment can be for any reason whatsoever. Now, what is the meaning of any reason whatsoever? Any reason whatsoever, there are so many examples. Some of them have been enshrined in the judgment itself. First is economy. The employer may say, I don't want to carry the economic deadweight of these people. These 3 workers, they are becoming surplus. Kindly look at me. How will I maintain them? I cannot afford to give them a salary per month. And that is why economy is one of the reasons. Second is rationalization in the industry or installation or improvement of new labor saving devices. Just think of a situation. Say, there were 100 workers and they used to carry gunny bags from this point to that point. Instead of 100 workers, what the employer did is, maybe he went to some bank, brought some loans, this, that, but he put up a conveyor belt. So now 100 people carrying gunny bags, they are not needed. You put the gunny bag on a conveyor belt, as you see it on airports, and the gunny bag travels there, and there are some people to pick it up and stack it into the godown. So in such cases, labor saving devices, and the employer is allowed to do so, because that is a right contained under Article 19(1)(g) of the Constitution in India, which is a fundamental right. Right to trade, right to profession, right to calling. These are fundamental rights. They are contained in Article 19(1)(g) in Part 3 of the Constitution. Then standardization or improvement of plant. Has anybody thought, say earlier, see both you and me were in college. And in the college office there were say 10 typists. And today, you cannot see typists there. Instead of those 10 typists, there are only 3 computer operators. And they do the work better because installed are softwares like Excel, PowerPoint and Word with so many. So it becomes easier for the management. And that is why what happens, management will say that I can keep 3 of them. What happens to the 7? As far as the 7 are concerned, under section 25G, following the formula, that is last come first go, the employer will make a seniority list. The seniority list will be from the date of joining, and whoever had joined last has to get out first. only after giving him a retrenchment compensation. And mind well friends, giving of retrenchment compensation is a condition precedent. You first have to pay the money, then only he can be retrenched. So under Sec 25G, last come first go. You pay the retrenchment compensation, paid to the second, paid to the third. Likewise, I pay 7 people and 3 I require. In the earlier example which I just now told you. Surplusage, or another word is superfluity. What is the meaning of the word superfluity? Superfluity means workmen who are in excess. It is that fulcrum around which this concept of retrenchment revolves, is what the learned judge says. If there is no superfluity according to the Honorable Court, there cannot be any retrenchment. So surplusage is the basis, superfluity is the basis of every retrenchment. That is the mandate which is contained in this judgment. Well friends, a most important question is answered in this judgment, that there is a shift in the approach of the court. What about back wages? Can back wages be asked as of right? And in this judgment, the Honorable Judge writes, they cannot be asked as of right. Grant of back wages, they are not granted automatically. And of course, there's one more question, whether the workman was gainfully employed or not gainfully employed. Now this question has to be answered on the anvil of section 106 of the Indian Evidence Act, whether he was gainfully employed or he was not gainfully employed. And there are several factors further down to consider back wages. They have to be considered as to nature of the appointment, mode of recruitment, length of service, is what the Honorable Judge holds. And then as far as back wages are concerned, the concerned workman, where was he employed? This can be easily found out. There are ways and means in which it can be found out. And of course, in the case of, say, there's a judgment mentioned in this case itself, that is by Honorable Justice B.N. Krishna, that is Indiana Engineering Works was Bombay Private Limited. In that, the Honorable Judge has even expressed that though cast iron rule, no cast iron rule can be laid down that this is the quantum of back wages which is to be paid, but the workman can also be honest and he also owes a duty whether he is employed or not. This is the finding in the judgment. But friends, coming down lastly, retrenchment we find this theory is even present in the judgment finally. And on the conspectus of the entire judgment, we find that it's a managerial function and it's the employer. The only one factor is Chapter 5A and 5B of the Industrial Disputes Act. 5A, as you understand, less than 100 workers are employed by the management, workmen I say. Chapter 5B applies, it's not 100 employees, it's 100 workmen. Then only Chapter 5B comes into picture. In that situation, then you have to take government permissions for retrenchment. If it is below 100 workmen, then you need not take government permissions. So in a way, friends, we have discussed the judgment threadbare and in the most simplified form as we understand. So this is the concept of retrenchment held as late as in a judgment which is in 2020. Thank you, friends.